If the hospital you go to fails to provide you any type of emergency care, including abortion care, you can now tell on them straight to the federal government, putting their federal funding in jeopardy. Now, before I tell you about the complete overhaul of this entire complaint system and how you can file a complaint, I want to thank my subscribers for voting for this story as the bonus this week. If you want to vote too, make sure you subscribe to my page during my next live event, or you can follow these steps and you can subscribe right now. Okay, first I need to explain the law. Under the Emergency Medical Treatment and Labor Act, a nearly 40-year-old federal law known as EMTALA, hospitals receiving federal funds, which is like most of them, must stabilize or transfer patients needing emergency care. Hospitals must provide the care regardless of the patient's insurance status, mental illness, or other complications that might otherwise lead hospitals to turn them away. If patients believe they were wrongly turned away, they can file a complaint, a process that can trigger a state and federal investigation and could threaten the hospital's funding. Now, for years, those patient complaints have been routed to state health agencies, which conduct these lengthy investigations and help determine whether a hospital actually broke the law. But because the system has largely been handled by the state, sort of behind closed doors, and varies from state to state and is very complicated to navigate, federal officials and advocacy groups have for years been questioning whether it's efficient and whether it works right. So just recently, the Biden administration decided to overhaul the whole process. The Centers for Medicare and Medicaid Services created this new, easy-to-navigate web portal for patients to send complaints directly to the federal government, which ultimately is the one responsible for enforcing EMTALA and penalizing hospitals that don't comply. But if you live in Texas, you are an exception to the abortion part of the EMTALA rule. Why? Because after the Supreme Court overturned Roe v. Wade, the Department of Justice issued legal guidance to all hospitals in the United States saying emergencies covered under EMTALA include, but are not limited to, ectopic pregnancy, complications from pregnancy loss, and emergent hypertensive disorders like preeclampsia. And yes, by federal law, stabilizing medical treatment under EMTALA could be abortion care. And no, according to the DOJ, it didn't matter what state you live in. The state of Texas, of course, sued, and a judge ruled that Texas does not have to abide by the abortion part of that legal EMTALA guidance. Now, if you live in any other state and you want to file a complaint, or if you live in Texas and you have another EMTALA type complaint, I will email the link to the new complaint form out to you in my next News Girl News Roundup email, so make sure you sign yourself up.